All right, well, we have a good group on. I imagine more people will be joining us, but I'll just give a quick intro while we let everyone in. So welcome everyone. My name is Becky Feldman Edwards. I'm from USGBC LA chapter. I'm really excited to welcome you today to this second conversation on construction with leading ladies. Thank you so much for taking the time to be with us. We're happy to have you all here. Just so you know a bit of the layout, because there are so many of us in so many different working situations right now, we ask that you just keep yourself muted during the presentation unless you're asking a question. There are two different ways to do questions during this webinar. You can use the chat box, which I will type into to ask any questions during the presentations. Our presenters will also stop at various intervals to see if any questions have come up. I will either read them off, or at that point, you can definitely feel free to take yourself off your microphone and ask. And then we'll also do some Q&A at the end that can be a bit more interactive and conversational. So you can also hold until then. Whatever works for you, we're flexible and here to learn and inform. So I wanted to, first of all, thank our wonderful partners at Hunt Ortman for putting on this content. Today you'll be hearing from Kathleen Smith and Jennifer Tung, and without any further ado, I will throw it over to them.
All right, thanks Becky, and thank you to the USGBC LA. Hello everyone, and welcome to the second installment of our complimentary webinar series with the USGBC's LA chapter, Leading Ladies. I'm Jennifer Tung.
And I'm Kathleen Smith.
And we are attorneys with Hunt Ortman. We're located in, formerly located in Pasadena, California, now pretty much located everywhere throughout the LA region. And like Becky said, thank you for taking the time to join us today. We know that everyone has a lot going on in their lives right now, so we appreciate you taking the time out to be here with us. In today's episode, which we've called May the Force Majuere Be With You, we're going to be discussing contract terms and legal doctrines that address how and under what circumstances, an unforeseen event might excuse a party from performing under a contract.
Yeah, and we just wanted to say that this is a really challenging area of law, that lawyers and courts struggle with it. So we expect that there can be some questions, and we want to engage you all in that kind of discussion. Because we have, the separation, the technology separation, it might be a little bit more challenging than if we were in person, but we do want to encourage anyone who has questions to make sure that they are either utilizing the chat function or we can have a discussion at the end. We're slated for a half hour, but depending on what information and what you guys need, we'd be willing to stay on a little bit longer. USGBC has said that they would be able to host a little bit longer on that should you have any questions. But I do want to kind of condition you to a couple of things, is that this is a dynamic area, especially given the new COVID-19 pandemic and the fact that we're, mid-cycle. We have no idea where we're going to end. And it's our prediction that we will likely be looking at a lot of lawsuits that involve some of the concepts that we're going to be discussing today. So we really want to arm you with information and, kind of set the stage for where we think things are going to go. But like anything, this is very dynamic, and we want to make sure that you understand that we're giving you the information so that you can start identifying some of these issues, but that you really should be following up with your trusted advisors, which is obviously your legal counsel, but your project team, your consultants. They're going to be your backbone as we maneuver through this time, this somewhat unprecedented time. So I want to make sure that we're answering your questions, but there's going to be a lot of it depends if we start getting to case specific as to what's happening with you currently. So don't want to belabor that, but just wanted to say that we're not just being cagey attorneys. It really does depend. So, okay, so let's continue. Maybe.
All right, so no doubt everybody has been hearing this term force majeure, thrown around a lot lately, probably more than what you're used to. In the US, when people hear force majeure, they often think, quote, acts of God, which is a nice, vague, like catch-all term. But that can be misleading. So, quote, acts of God can be a type of force majeure event, but those aren't the only things that force majeure provisions often include. And we'll talk about that a little bit more in a couple of slides. Legally, though, what does a force majeure contract or provision mean? It's a legal excuse to contract performance. It's basically an escape hatch from a contract. So force majeure provisions seek to shift risk. For example, like let's say you're a builder and you're building a sports stadium. A massive hurricane comes and wipes your sports stadium out, but it also just decimates the entire area. And so it's physically impossible for you to continue building. So in a scenario like that, who is going to be responsible for the additional costs? Who's going to be responsible for the additional delays? Is it the builder? Is it the owner? Who's going to be responsible when no one party was really at fault? So that's what force majeure provisions try to do. They try to address scenarios like that where an unforeseen event happens and they try to shift risk among the parties in a scenario like that. Next slide, please. So here is a sample force majeure provision. We wanted you to have a concrete idea early on in the presentation of the kind of contract provision we're talking about today. So, one thing that this is a sample, a pretty typical sample coming to us from consensus docs. And one thing that you might notice is that the terms force majeure don't actually appear anywhere in this provision. However, the provision does talk about, delays caused beyond the control of the constructor. So that's how you know that this is the force majeure provision, because it talks about delays caused beyond the control of one of the parties. Some force majeure provisions will only include that phrase, things beyond the control of that party. The sample that we previously looked at, though, lists a couple of your typical force majeure events. For example, towards the bottom, it says labor disputes, general labor disputes, fire, terrorism. This one includes epidemics. So, so just to give you a sense of the kind of events that force majeure provisions often include. All right, so an important thing to remember about force majeure is that they are creatures of contract. They are not implied rights. There's no common law right to a force majeure provision. So if you want this type of escape hatch in your contract, then it's something you have to negotiate and agree to with whatever party you're contracting with. Like contracts, though, force majeure provisions, they vary greatly. So make sure you go back and you review the kinds of things that your force majeure provision includes. You may or may not have really focused on force majeure provisions in the past, but, and so they might seem super unique right now. And in a sense that they are, because they address, big unforeseen events that you typically don't encounter. But force majeure clauses aren't the only ones in your contracts that seek to excuse one party or another from performing. For example, you probably have a lot more experience dealing with provisions regarding delays or extensions of time, price escalation, and one party's ability to terminate or suspend the other party. All of those are contract provisions that seek to excuse performance that you probably interact with on a more regular basis than you would the force majeure provision. Okay, so as you saw in that consensus doc sample that we had, force majeure provisions, they traditionally cover things like natural disasters, fires, floods, earthquakes, hurricanes, acts of war, terrorism, strikes, embargoes, pandemics. More and more, though, you're seeing force majeure provisions start to include things like computer hacking, cyber warfare, and piracy. Okay, so you have a general sense of what force majeure is and the kinds of things that it might cover. But, you know, the critical question that is on everyone's mind right now is, well, is COVID-19 a force majeure event, and are you in particular covered? So like Kathleen said, you know, this is a very dynamic area with COVID-19, and it's a very substantively thorny area just in general. So we can't give you legal advice, but we can at least touch on some of the key things that you should be looking for when you're looking at your force majeure provisions, but also the kinds of things that your advisor team is going to be analyzing to see if the force majeure provision will apply in your particular scenario. So when you're looking at your force majeure clause, your first step is to look for the kinds of events that are included. Again, those are the things that we talked about, like the terrorism, the wildfires, the earthquakes, pandemics. Some force majeure provisions will include like a catch-all phrase, you know, for example, anything's beyond, you know, party X's control. So if you wind up in litigation and you're trying to litigate a clause that's a catch-all phrase like that, you should be aware, though, that courts will often interpret those kinds of broad catch-all phrases quite narrowly. So, for example, you might have to show that the specific event that you are saying is a force majeure event was contemplated by the parties, that the parties actually had that kind of thing in mind when they negotiated and agreed to whatever provision now appears in your contract. So, you know, let's see. So everyone's understandably worried about COVID-19. Let's say your provision says acts of God are covered, only acts of God are covered. You know, COVID-19, you know, might fall outside of that scope. If a provision specifically references pandemics or epidemics, then COVID-19 impacts may be included. If your provision doesn't say pandemics or epidemics, but it says something like government actions or government regulations, then COVID-19 impacts may still be included. But that's with a big caveat, especially here in Los Angeles. You know, in California and in LA in particular, construction has been deemed to be an essential service and has largely been allowed to proceed. And so we'll talk a little bit more about that later, about why that's important, but that definitely factors into whether or not you're going to have a force majeure event because of the COVID-19 pandemic. So not just the kinds of events that are included, another thing that you should be looking for when you're reviewing your force majeure clause to see if it's applicable is just how far down the chain is it applicable. You know, for example, your supply chain. What if you are not directly impacted, you know, because, you know, construction is allowed to continue in Los Angeles, but what if your supplier is directly impacted? What if all of the materials you import are imported from Italy? You're pretty much going to have, you are going to feel an impact there, but does your force majeure provision cover that? So how far down the chain does your force majeure provision go? So those are two of the things that you should look for when you're reviewing your force majeure provision. You know, what kinds of events are covered and how far down the line does it cover? A second step in determining whether or not you're going to have a force majeure event is how difficult does performing your job have to be before your contract will excuse you, before you can be excused from performance. So a lot of force majeure provisions require that the party be prevented or unable to perform. So that means that it has to be basically impossible for a party to perform instead of just being more difficult or more expensive. So for example, state and local government have ordered all wedding venues shut and have prohibited public gatherings of any kind. So that wedding venue is going to be prevented from providing its service to, you know, the couple that had previously scheduled to have their wedding there. You know, but what about unforeseen events that make your work more challenging. It's way more expensive now. It's way harder to do your work. Coordination difficulties, regulations impacting work, and disruptions in your material supply chains. What about those? So that is a much trickier issue. Kathleen's going to touch on it a little bit more later in this webinar. But the general rule is that force majeure provisions won't excuse you from performance if performance is simply harder or more expensive. So, you and your advisor team are going over your force majeure provision. You've looked at the broad categories of events. You've looked at, how far down the supply chain it's applicable to. And you've looked at the prevention or inability to perform standard. And you all agree that you think you have a force majeure event on your hands. The other thing that's important to consider, both when you're reviewing your current provisions, but also when you're negotiating your next ones, is what is your remedy? So you've got this force majeure event and you want to be excused from performance, but what is your remedy? And, you're being impacted. In the sample that we saw, the remedy there was an equitable extension of contract time. So you get more time. Some provisions will include an equitable adjustment in contract price, and some provisions will include both. So for example, though, let's say your provision allows you an equitable adjustment in contract price. The analysis, again, doesn't stop there. You got to scratch a little bit beneath the surface. Is it only your direct costs, the indirect costs that you get an equitable adjustment to? Do you get to mark up for profit? Do you not get to mark up? Unexpected costs for demobilization and remobilizing your forces. Those are all things that you should bear in mind when you're both reviewing your provisions, but also when you are looking to negotiate your next one.
Okay, and so I'm going to pick up from where Jennifer left off, because she indicated that there are contract terms that are designated for force majeure events, but then you also have other contract provisions that may actually provide you with some coverage. The first of those was actually where we saw the sample that we gave, which is in the delay provision within your contract. Obviously, as members of the construction industry, you're very well acquainted with the way in which projects can get delayed under the best of circumstances. Well, unfortunately, we don't find ourselves in the best of circumstances right now. And so when you go to your lawyer, there's going to be a couple of provisions that we're going to look for. The first one we're going to look for is an actual force majeure provision. But without that, the next area we're going to look in your delay, the delay clauses. Obviously we have compensable and non-compensable delays, and even within that, there is still a lot more that can be dissected. There are going to be many more contracts in the private works of improvement that allow for extensions without any kind of compensation. In the public works realm, that doesn't really work. There's a much narrower field where you can get a no compensation for delay clause through and enforced by a court. But in private works of improvement, it is a fair and enforceable provision. So even within your delay clauses, you're going to have to look to see what your potential remedy is should you come to a situation in which you are being delayed because of some kind of unforeseen circumstances. Obviously, no one expects a pandemic. So when you have a provision that actually calls for both compensation as well as an equitable extension, there's also the potential that there has been already negotiated what costs you will be allowed to charge back to the owner. Or if you're an owner, what costs you are allowing the contractor to submit as a proper change order. Being aware of those limitations is particularly important when you are working on a public work of improvement. The notice provisions that are in your delay clauses are much more strictly enforced. and also any claim for additional compensation that is not otherwise allowed under the terms of your contract, in a bad situation could be the basis for the ownership group to push back and claim that you are claim false claim violations where you are seeking compensation falsely from a public agency. So obviously, knowing those terms and knowing what you can and cannot collect for is going to be a very critical component to any kind of analysis that you will be undergoing when you're looking at your delay. I briefly touched on notice, but notice in any project, regardless of the context. Obviously, right now we are in a very peculiar situation, but the notice provisions in your delay clauses are very important. They are critically important when you are on private works or on public works of improvement. But the reality is that, if you have said that you are going to be providing notice within 3, 5, 7 days of a potential delay event, there are a lot of courts who are going to hold you to that. So contract management and administration right now are skills that if you need some help, that's the area to focus in on, because it could be the difference between you making out, well, maybe not as great as you think you should, but making out okay, as opposed to not being able to claim certain very significant amounts of money that would otherwise have been due, had you complied with all of the notice provisions. Also, in certain circumstances, there will be price escalation clauses. If you're in a lump sum situation, it is unlikely that you are going to have any kind of contract provision that sets out any kind of adjustment for additional costs of labor or additional costs for goods. But there are certain circumstances in which you might be able to see that cost plus design build contracts will often have at least some kind of contingency plan for some kind of material escalation. There may be some triggering mechanisms within that will allow for the contractor to claim an additional component should the price of certain goods increase by X%. Should you have those in your contracts, it's also another really good thing to look at should you be experiencing any delays or material price escalations in this particular time frame, because it is likely to happen as things progress down the road. It would be nice to be able to be more predictive of when goods and services will really kind of return back to normal. But I think that we're all in a better situation if we recognize that this is months more of us prepping, and then potentially going back to what hopefully going back to normal soon. Termination and suspension clauses. I know that oftentimes no one really wants to look at their termination and suspension clauses because ultimately that means that the project is either going to be stayed, and so you can assure yourself that you're not going to be paid for some time, or that you may not be paid anymore. But there is another way in which you can look to see whether or not you have any rights under your contract, to see what costs you can recover should the ownership group decide that that for economic reasons or timing reasons or whatever the case may be, that they either suspend or terminate the contract to either allow for things to calm down. Should there be reported cases of COVID on a particular project and the particular project comes under more scrutiny, there may be a requirement that they have to shut down or increase certain kinds of regulation and inspections. But those two contract clauses are going to set out what additional costs you will be able to claim against an ownership group, or if you're the owner, what additional costs you should expect from a change order request. Obviously, within the suspension, there's going to be, additional demobilization and remobilization costs that weren't initially contracted or foreseen. And so in that way, there's going to be a significant amount of increase in whatever the contract price is going to be because of that. And those costs could be significant and may make the difference between whether or not you will actually suspend the project or see about alternatives that will keep everyone on site and have the money going, but just allowing progress to be slowed. Termination for convenience clauses often have a set schedule of what fees and costs you can collect. Those typically include actual costs incurred to the date of the notice of termination, as well as any kind of reasonable costs that are incurred as a result of the termination. Sometimes there will be termination costs for, subcontracts or canceling certain supply orders. So you'll have to look at those clauses very closely to see what kind of adjustments you'll be entitled to should the project actually go that way and either be suspended for some period of time or the contract actually terminated. And we started off talking about your contract terms, but here is where I think things get interesting from a practitioner's perspective. And also a lot more muddied. So it is in this realm that there's going to be a lot of hedging, simply because if you were to ask me right now, the equitable doctrines that have existed in California for over 100 years are going to be the areas in which there's going to be, unfortunately, I think, a lot of litigation. There are three primary equitable doctrines that California recognizes, and two of them I'm going to collapse into one because essentially that's how the courts treat them. So commercial impracticability and impossibility are used almost interchangeably when you're going through the case law on these equitable doctrines. Frustration of purpose is its cousin. It stands in place for it. So since construction was identified very early as an essential business, there were more projects that continued than stopped. And so when we talked about force majeure, what we talked about was that one of the triggering events is that you were prevented from being able to perform your work, or that you had some kind of inability to perform your work. But that's not exactly where contractors found themselves at this time. Instead, what they found was that there were additional regulations and additional hurdles that needed to be overcome in order to keep these projects on schedule and on time, certainly not on budget. So what commercial impracticability and impossibility do is that they are an equitable doctrine. I'll just go to the definition, so it's easier that way. That an unforeseen event or condition that happens after the formation of a contract has made the performance of the work impracticable. It's not impossible, but it's impracticable to proceed, and that it is not, that unforeseen event is not the fault of the party that is seeking relief. So what does that really mean? Well, it is an affirmative defense, which in legal speak is a justifiable excuse for non-performance. So just like the force majeure was an opportunity to risk shift and give a legal contractual right to the parties to non-performance, this is the court's attempt to give some kind of equity balancing should an unforeseen circumstance happen during the project that would give someone the excuse to either stop performance or seek additional money. And I say that knowing that the second bullet point on my screen right now is that an increase in expense is not impracticability. And there's a good reason for that, is that the rule is that mere expense, mere cost, mere increase of expense is not going to be so significant as to rise to the level that a court will legally excuse a party from performing its obligation under a contract. Instead, it has to be something more. It has to go to something more objective, which is that no one can perform the task, the purpose of this contract, rather than it is impossible for me as the contractor or me as the subcontractor to perform it because of some additional cost that this unforeseen event or condition has caused. But here is where, all of the exceptions start coming in. And I'll tell you that when you go through all of the case law that I have gone through on these issues, that where you really see commercial impracticability come up is what you'd expect. It comes up during wars and it comes up during embargoes of some sort. And the courts are very hesitant to rewrite contracts for people. So they always start first with what's in your contract, what have you as the parties to this contract agreed? What risks were you willing to take on? What rights do you have? What damages can you claim? And they're very hesitant to do anything that is going to upset that balance. So they are only going to take action in those most extreme circumstances to essentially breathe in some kind of fairness when no one expected something to happen, and that it really is not completely fair for one person to suffer the risk of this unforeseen act or condition. So although I say that increase in expense is not by itself impracticability, there are some cases that if it is so significant and so extreme and that it wasn't reasonably foreseeable that you should have allocated this risk, that courts may be inclined to allow for this significant increase. And when I say significant, I'm talking in the magnitude of 10 to 15 times the actual expense that was previously identified in the contract. So it's a big number. They may be inclined to find that whatever unforeseen event or condition gives rise to this defense of commercial impracticability. But because there is an expectation that the parties are going to do for themselves and balance the rights and the risks and the obligations, it is an uphill battle, and that courts are not going to be necessarily just welcoming and opening up their arms to all of these lawsuits and identifying that this is the way that they're going to handle this. And the different ways that different industries have been treated during this COVID-19 outbreak is going to be, pretty significant. Construction stayed open. So to me, I still feel like there's going to be more litigation in construction that deals with this commercial impracticability side, and potentially even frustration of purpose. And I say that knowing that I somewhat skipped over the definition of what the frustration of purpose is. But, it's the cousin of all of that we've been talking about, which is just that an unforeseen event totally or nearly totally destroys the purpose of the contract. So we see that more in the true natural disasters where, hurricane comes through, ruins everything. Now there's no building, no one's coming to that area. The beach is gone. So there's no point in continuing the hotel project because you're never going to have the same kind of tourist industry as you once did. But courts are going to be hesitant to be too liberal. And I say that knowing that California, of a lot of states, is probably one of the more liberal in interpreting commercial impracticability, but it is a very slippery slope, and they don't want to get into the practice of rewriting contracts, of giving more rights, especially when the parties in the first instance weren't willing to negotiate those rights for themselves. So we started with the contract principles. because those are very important. Those are the ones that you can see in black and white, and you can walk to a courthouse and you can actually, ask a court to interpret those particular clauses, and you can breathe life to what your intention was at the time that the contract was entered. When you start getting into some of these equitable doctrines, there's going to be a shift, is that you no longer can look to the black and white. You're going to look to the totality of the circumstances and the way in which this particular fact is so extreme that you should be excused from performance, or that you should be paid for the extreme nature of the change between what you expected to give and what you actually had to perform.
Kathleen, we have a question. Would it be a good time to jump in with that, or do you want to hold till the end?
No, it's a perfect time.
Okay, so the question is WeWork licensed a commercial impracticability because they can no longer perform the service of offering co-working space?
That's interesting. So they're going to, because they had to shut down. I mean, office buildings are, one of those things that have not had to stay open. And WeWork is interesting because they don't necessarily have a particular industry. They're essentially, middle persons leasing out space to a whole host of different industries. So the fact that they have had such a strong business disruption because of their, unique space in the market, they could claim, depending on what their contract terms are, they can certainly claim force majeure. They'd probably be in a better place to do it via contract because they were in a pretty decent negotiating position. But all of these same principles are open and available to them. They could claim that it was impossible for them to provide any kind of space because they were not considered a vital business, an essential business. But it really is an interesting issue, because when you boil down what their business is, they lease space, and that is not an essential business. And there is a whole host of emergency orders that specifically address what happens with those leases and what you can and can't do with those leases.
And then do you know how this then affects their customers? Because I actually know, in regards to this question, I know quite a few people that have WeWork spaces and they're still being required to pay their rent, although WeWork has ways to get out of paying what they're paying to the larger buildings.
Yeah. And of course, that's also interesting in the way in which the domino effect happens, is that, depending on the terms of your contract also depends on what your rights and obligations are. So WeWork, having negotiated pretty decent lease terms, may be able to, like you say, get out of having to pay certain, month's rent. There's a difference between what you're legally obligated to do and what you should do. So, that is always kind of at stake. So it would always depend on what your agreement with WeWork is about these co-sharing spaces, and what rights you have under that. Now, does that mean that they are going to suffer greatly from the court of public opinion? Probably, because it seems like it is, quite aggressive to accept certain benefits of these emergency orders and not be willing to accommodate the people who are, that you are providing these office spaces to. Certainly, but ultimately, it's going to be a hard sell to get a court to say, commercially impracticable, and you are excused from, paying your rent. Again, this is assuming that this is not covered in some, emergency order, whether it's, county by county or statewide, that deals with some of the landlord-tenant issues. because I do think that WeWork is probably going to have a business model that's more in line with that. And so any kind of issue that you may be having with that is likely going to be tied, or at least well analyzed, against the landlord-tenant roles and having rent deferrals and things of that variety. But this is an onion. You can keep peeling back the layers, but ultimately you always start with your contract. You always have to start with your contract, because where you don't want to find yourself, why the slide was called, Plan B, Plan C, and maybe Plan D, is that you don't want to find yourself in the place where you have to rely on those equitable doctrines, because one judge may not see it the same way as another judge, and both of those cases, go through trial and ultimately, courts of appeal, and, potentially if there are conflicting rulings, to the California Supreme Court, it could be a long way away from having a lot of resolution on whether or not your particular equitable circumstance is going to be deemed justified. And it's going to be a lot of lawyers' fees, and it's going to be a lot of effort. And so your first order of business is to always look at your contract and see what you have put in there to protect yourself.
Excellent, thank you. That's the only question we have on chat thus far.
Okay, so lessons learned. I think I probably stole a lot of it. So I'll let Jennifer go through some of those.
Kathleen's right. The important thing just always start with is your contract. So first lesson learned, review your contracts, review your force majeure provisions if you have one. Again, a couple critical things to keep in mind. Look for what kind of triggering events are included in your force majeure clause if you have one. Look to see whether or not that force majeure provision includes direct impacts only, or even potentially indirect impacts. Look to see what your remedies are. Do you get extra time? Do you get extra money? Do you get both? Do you somehow split the impact costs with your contracting party? Another important thing to remember is, like Kathleen touched on, is comply with your notice rules. A lot of force majeure provisions and a lot of provisions throughout your contract in general, whether it's suspension and termination provisions, seeking additional compensation for delays, they all have notice rules. So if it says that you need to provide notice to the other party to the contract within 3 days, 7 days, weeks, got to make sure you comply with that, because otherwise that is it's an easy win for the other side if you end up litigating it. And track your expenses. If you do end up fighting over force majeure provision, and you are making the argument that you are entitled to an equitable adjustment in your contract price, you're going to have to be able to prove the additional money that you think is owed to you because of the unforeseen event that happened. So definitely review your contracts, comply with your notice rules, and document and keep track of all of your expenses.
Sure. And, we have this negotiate thoughtfully and strategically. And we want to make sure that you all realize that the time of contract isn't the only time to implement good, thoughtful, strategic negotiating skills. That there are owners who are considering what their financial obligations are right now and whether or not they're going to be in a place where they can complete these projects. This is a good time and a good opportunity for partnering and negotiating, whether it is a suspension of work or negotiating, the terms of a termination. Just because your contract says something doesn't mean that there isn't an opportunity to deal with it now in a different way. So don't think that just because the contract, says one thing, that you shouldn't at least engage in the conversation. Good relationships between the construction partners is always going to you'll have a better result than if you go down the lawsuit route. I can tell you that from, many years in this litigation game, that, there are opportunities that unfortunately aren't always capitalized on during a project that could, potentially avoid some of the pitfalls that, come with litigation. So certainly this is going to be one of those times where there's going to be a rise in the negotiation of force majeure clauses. There's going to be a rise in looking at some of these other provisions that we've talked about, and it's okay and it's good. But just because your future contracts are going to be, more mindful of what unforeseen circumstances are going to be covered in your force majeure and how you're going to address these things, doesn't mean that there isn't an opportunity now with the contracts that did not anticipate an epidemic happening, that you're out of luck. This is a good time to double down on your relationships and, see what you can do about partnering with your contractor or with your owner to see about some kind of resolution where, everybody walks away, maybe with some bumps and bruises, but no one has, a gaping wound. And then obviously, I know that it sounds, like we're peddling, but you really need to take this opportunity to get to know all of your trusted advisors. Is that, consulting on these things, when you start seeing projects going south, or if you're noticing that, your supplier is, needs more lead time for things, consult with your attorneys, consult with your claims consultants, delay experts, whomever you have good relationships with, whether it's through litigation or it's just true partnering on making good, effective business decisions during your project. This is a good time to pick up the phone and start having these conversations, because having a couple of hours worth of attorney time to help steer the ship in what can at best be called foggy conditions is going to save you a lot of time, money, and energy at the very end of this. The old saying, what's it, a pound of cure is worth an ounce of prevention, probably vice versa. But that's really where we are right now, is that we are not to the end of this road. This journey has just begun, and you need to be mindful and you need to take those good strategic steps. And often that includes consulting with your trusted advisors. Sometimes it's painful. You know that you're going to get that bill at the end of the month, but I will tell you that consulting with these advisors now is going to give you a leg up on resolving some of these conflicts as, things materialize and hopefully, but most likely, compound. I know that it sounds a little self-serving, but this is what we do. We look at contracts, we analyze, we strategize. And I know that all of you are, very capable and sophisticated, and you have the right people in your saved your Rolodex in the old times, and then, on your favorites menu now. So use them. We're here for that. So we went over a lot of information, and I know that some of it was as clear as mud. So I'm not expecting you to feel like you've got, all of this covered, but, hopefully we've armed you with, some good information that as we take these steps forward, you feel a little bit more confident in the information and, familiarize yourself with your contract terms so that you can negotiate for yourself better.
We do have another question.
Okay.
This question is from Jason Jones at LA County Public Works. Could you provide a specific well-known example of a commercial project in LA County in which force majeure was successfully argued and favored the contractor? And then another example in which the contractor was unsuccessful.
Well, there are many more unsuccessful than successful. But, rattling off the top of my head, I can't. but the circumstances, I think, are there. The circumstances are there. And so while I can't give you a specific example and show you a building or show you a bridge, you know, I know that when you're going off script, when you're going to the equitable doctrines, it is more often than not, you will not be successful in being able to claim this equitable forgiveness. And most of the time, what you see that in is, you know, again, they peak after wars, they peak after embargoes. And so you'll see cases involving car dealerships, you know, right after World War II. You'll see sign makers right after World War II when there were issues with, you know, lights at night. So when you read the cases that have dealt with this and have struggled with some of these concepts, it's not surprising that you're seeing them in, you know, very extraordinary circumstances. You know, modern times, we haven't had to deal with it much. Very thankfully, we haven't had to deal with it much. But that's one of the reasons why, you know, a lot of people find themselves in, you know, feeling very unsure-footed right now.
That's our only question in chat, but I welcome anyone to either chat me a question to the group or directly, or you can probably go ahead and unmute your mics now and ask if you would like to do that as well.
I don't have a question, but a comment. I've been involved in force majeure cases and found that sometimes some of the events give rise to an insurance claim where there may be coverage through a carrier for a force majeure event. So don't leave that stone unturned.
That's a great comment, and I know that voice. So yeah, that is definitely something to think about. A lot of policies do have business disruption or some other rider that you should look to. In times like this, you know, all of your project documents should be reviewed. That includes your insurance policies to see what kind of coverage you may have outside of the general contractor owner or general contractor subcontractor relationship.
Okay, excellent. Are there any remaining questions before we wrap up? Excellent. I really just want to thank everyone and take the time to do a little closeout where we tell you what is coming next. So this was the second in a series of Leading Ladies Conversations on Construction. The next episode will be happening on July 23rd on consequential damages in green buildings. So please tune in for that. And then here's some other great content that we have coming up at USGBC that you may be interested in. I do want to let you know that a recording and a PDF of the slides will be available after the presentation. So you will get an email directly from USGBC LA, including that, so that you can have the content available to you. Other things that we offer at USGBC that I just wanted to let you know about is our talent portal. It is a green jobs portal, a place to find all upcoming webinars and all good stuff like that. So we welcome you to engage there. We also have our MGBCE 2020 conference going on. It is supposed to be at LA Trade Tech in downtown LA, but we are anticipating a virtual conference this year. So it will at least be partially, if not fully digital. So look for more great content there. And then Thank you to all our sponsors and partners who make this content possible. We've really loved being able to adapt to these times and provide you all of this digitally. So thank you so much for joining us. And thank you, Kathleen and Jennifer, for the awesome information. We really appreciate it and can't wait for our next episode.
Thank you, guys.
Thank you, everyone.
And everyone for participating.
Thanks so much. Have a good and safe day, everyone.
Thank you. You too.